Welcome to my channel. Please like, comment, and subscribe. Maritime injury statutes of limitations. When you get injured on the job in your maritime industry, you have rights. You have a right to compensation to cover associated costs, and you have a right to sue your employer if you are being denied that compensations. The maritime laws are there to protect you and the people who depend on you. But it can be complicated. There are time limits on when you can file a claim or start a lawsuit. Knowing which law applies to you, what the statute of limitation is, how to file a claim, and what to do next is on always officious. An experienced maritime lawyer is the professional you need to make sure you take all the right steps to get your money. One of the most important mistakes you want to avoid is being too late to file claims. Each law has its own statutes of limitations, so when you get injured on the job, you or your representative must act quickly to ensure you don't miss out on your benefits. And the next, the Jones Act. The Jones Act is the federal maritime law that allows seamen to sue or file a claims against an employer when that employer's negligence contributed to an accident with an injury or death. If you qualify as a seaman, have been hurt on the job, and can show that your employer's failures to act in some way contributed to that injury, you can file a claim under this law, but there are limitations. The statute of limitation for the Jones Act is pretty reasonable, so there is no excuse not to file a claim during these time periods. You have 3 years from the time of the accident that caused your injury or illness to file a claim or start a lawsuit. There are some exceptions. For instance, if an accident triggers an injury or illness, but symptoms did not become evident until later, you have 3 years from the time of the onset of symptoms to file, not from the time of the incident. And then next, the Longshore and Harbor Workers' Compensation Act. The Longshore and Harbor Workers' Compensation Act, or LWCA, is federal workers' compensation program that applies to many maritime workers not qualified under the Jones Act. Unlike that law, you do not have to prove any negligence to get benefits under the LHWCA, but you do have to qualify as a longshoreman or harbor workers to apply for those benefits. The statute of limitations on this law is 1 year after the time at which your discovers an injury that was caused by your job, or were diagnosed with an illness found to have been caused by your job. If your employer has already started paying for your medical expenses and other costs, your time limit begins as soon as those payments cease, and it extends to 3 years if your employer refuses to pay your benefits. And then the next, the deeds on the high seas assets. DOSSA, the Deaths on the High Seas Act, is a federal law that covers expenses for seamen who have died while on the job and out to sea. The compensation from this law goes to dependents, members of the deceased's family, usually the widowed spouse and any children. The law also applies to offensive accidents that occur 12 or more nautical miles from the U.S. coast. As with the Jones Act, there is a 3-year time limit on filing a claim under the DOSSA. Time is needed to investigate the fatality and to calculate the compensation owed to the family. And then about the Outer Continental Shelf Land Act. The Outer Continental Shelf Land Act has many purposes, but for workers on platforms and rings and other semi-permanent or permanent structures in offshore areas. It acts like a workers' compensation program for on-the-job injuries and illnesses. If you work offshore, you can file a claim under this law to get benefits. It was extended to cover workers like you who were previously not covered under the Jones Act or LHWCA. The limitations on filing under this law depends on the location. You may have between 2, 3, or 4 years to apply depending on which state's coast was nearest to where you work and were injured. And then next about maintenance and cure. Maintain and cure is an old maritime law. It provides seamen with the right to maintain or living expenses and cure or medical expenses while injured and unable to work. The law is based on the facts that seamen, when on the job, have their living and medical expenses covered by their employers. If you can't work because of an injury, you are still entitled to that coverage. The statute of limitation on a maintenance and cure is not set in the stones. Thank you for watching this video. Don't forget to give like, comment, and subscribe